Good afternoon and welcome to part 2 of Schoeneck King's webinar series on data privacy and cybersecurity for higher education institutions. This webinar series focuses on the intersection of data privacy and cybersecurity with higher education. Today's discussion will focus on the contract management process and mitigating data privacy and cybersecurity risk in vendor contracts. If you have a question, please use the Q&A box located at the bottom of your screen, and we will do our best to answer your questions as time allows. Please remember to fill out the questionnaire following this presentation. Today, we are pleased to welcome Phil Zacchio to our series. Phil is co-chair of Schoeneck King's Higher Education Practice Group. His practice focuses exclusively on representing colleges and universities in all aspects of higher education law. Specific to our topic today, Phil represents institutions in negotiating a wide variety of vendor contracts, from full outsourcing of functions such as food service, facilities maintenance, and bookstore operations, to discrete product and service offerings from vendors serving the industry. I am pleased to be presenting alongside Phil today. My name is Amber Lawyer, and I'm the Deputy Chair of Bond's Data Privacy and Cybersecurity Practice Group. I maintain 2 privacy professional certifications in US and European law, and I assist higher education institutions with negotiating vendor contracts, specifically in technology and software areas. All right, so let's get started. Next slide, please. Today, we're going to work through risk mitigation strategies in the vendor contract space for higher education institutions, and we're really going to work from the pre-contractual phase all the way to an executed document and oversight and enforcement after the fact. We hope today will help you to mitigate risk and to realize the risk that comes along with cybersecurity and data privacy in relation to tech vendor contracts or vendor contracts in general. Thanks so much, Phil, for joining us, and we'll kick it right off. Next slide.
Thanks very much, Amber. And next slide, please. So we are going to spend most of our time today talking about the specific content of vendor agreements and ways in which particular provisions can either help or hinder you in managing risk, as well as some negotiation strategies to go after those issues. But before we get into that, as Amber mentioned, we'll just talk about a couple of pre-contractual strategic considerations. Often you'll find that it's possible to facilitate success on negotiating risk mitigation by considering when and how these issues are raised. And by that, I mean, our goal ought to be discussing or having these interactions with vendors on these sorts of provisions at a time when the institution has the greatest amount of leverage. And when in the contracting life cycle does an institution have the most leverage? Well, obviously, when a vendor is looking to get your business, when they don't know that they've got the award yet, but they're looking to persuade you to buy their service or their product offering. And so on that front, for gold standard here, and I realize that this is not possible with every one-off vendor engagement, but if you're using an RFP process, that just goes miles in enabling you to get vendor buy-in if they want the business on the front end to your preferred structure of risk mitigation provisions. So with an RFP, you require them to accept particular concepts or even particular contract provisions as part of the price of admission to your institution and providing the service. The flip side of this is just thinking about the contract form that you're likely to be using. And in many circumstances, if not most, the vendor will have their own form agreement. And in some circumstances, particularly in the technology sector, it does make sense that you're going to be negotiating off of a vendor form in terms of memorializing the arrangement. But the obvious downside of using a vendor template form is that they build those with their own self-interest in mind. And so you will encounter various provisions that either limit their commitments to you in terms of data security and privacy, or limit their exposure to you. One of the favorites that we'll spend some time talking about today is the wonderful provision where the vendor limits its liability, no matter how much harm they cause you, to a specific dollar amount or a formula that determines a specific dollar amount. Much more likely, obviously, to be encountering that if you agree to negotiate off their template, as opposed to those of you who have your own services procurement templates, and I know many institutions do. You can go a long way towards building in your preferred provisions there and using that as the starting point of negotiations when it makes sense to do so. And I realize it may not always make sense to do so. And then last, just in terms of a timing piece of this, when do you raise these sorts of issues with vendors? And regardless of whether you're using an RFP or launching straight into negotiations, once again, the goal here is to maximize leverage. So don't leave these kinds of concepts to the back end of a negotiation. The old anecdote about when you buy a car, you negotiate the value, the price for the car first, and then you wait and negotiate the trade-in value for your car later. That's your conventional wisdom for whatever reason. Reverse strategy here, right? Pull these kinds of liability and risk management provisions up to the front, negotiate them right alongside with the core business terms, the pricing, and the other things. Make sure the vendor knows that these are just important to getting to yes for you as the price of the service and the specifics of the service are. And that will enable you to exercise the leverage at the point that you have it to drive this kind of risk management strategy. Next slide, please.
Okay, so we're still somewhat in the pre-contractual phase here. When you've gone through the RFP process and you've started to select a vendor, it's really important for the institution to ask some core questions so that we can start working towards mitigating data privacy and cybersecurity risk. The first is always, what data is at play? What data is relevant to the agreement, even if the core services don't relate to any kind of data sharing? And so what data will be shared with the vendor? Will the vendor have access to institutional data, student information, employee information, maybe registrar information? And then when we receive the form agreement from the vendor, or if you have your own procurement agreement, do we need to modify your agreement in order to mitigate risk in relation to that data? So first question is always, what data is at play here? What are we concerned with? How do we need to modify the agreement? The second question is, will the vendor have access to institution systems? And so this is really important from a cybersecurity front. Will the vendor be accessing your internal network, your legacy systems? Are you integrating a software which will allow the vendor to access certain information? And do we need to limit that access? This is really relevant, and you'll see we've provided some sample language here because, of course, a vendor entering into your network, into your internal systems, can create risk. A vendor could cause some kind of issue, bring in some malicious code in your internal systems. And so what we want to do is incorporate terms to limit that risk. And so you'll see we've provided some sample language here just to show if we had a vendor that was accessing the client network, the institution's network, we would add something similar to what we've given here, which just limits the use of the network, provides protections in relation to passwords and accounts and use of those accounts, make sure that we mandate what access the vendor may have and restrict it if we need to, gives us the ability to limit that access or to revoke it at any point in time. And so these are really upfront questions. They help you to assess the risk, and they help you to start identifying relevant provisions that may need to be included in the contract if they are not already. Phil, do you have anything to add there?
I don't. The only other thing I'd add, Amber, a common question at this point, particularly given that we have some sample language and folks, you'll see sample contract provisions throughout this presentation. You will all have access to these slides after the presentation is over. So please don't feel the need to try to scroll out these provisions as we march through these slides. You'll get all of this after the fact.
Yes, thanks so much, Phil. Okay, next slide. Okay, so another very important aspect of the pre-contractual phase is appropriate due diligence of your vendors in relation to their cybersecurity posture. So we need pre-engagement due diligence in relation to a vendor's cybersecurity safeguards, security safeguards, and if they have any kind of attestations in relation to their security posture. What does that mean? Sometimes some institutions actually create a vendor security questionnaire, a diligence questionnaire that goes along with the RFP process so that you can start vetting your vendors before you enter into any contracting phase here. This is really important. You want to ask your vendors questions like, have you had a data breach in the last 5 years? How have you responded to that incident? What security measures do you maintain? How do you train your employees and your staff? This is the best way to mitigate risk up front, is to appropriately review all of your vendor security papers, posture, and policies and procedures. And so one of the ways that we see a lot of tech vendors and vendors in the higher ed space deal with this security diligence is by providing some form of security attestation. And so sometimes that comes in the form of a security white paper or defined documentation in relation to data security and the procedures that your vendor may implement. You'll also see that vendors in the higher ed space are willing to provide a HECVAT report, so a higher education community vendor assessment toolkit report, or a SOC type 1 or type 2 report. They may be willing to certify within the contract that they meet an ISO 27001 certification, or that they're compliant with NIST standards. And so all of these standards, attestations that I have listed here, they're all ways for us to vet the vendors and make sure that they have adequate security posture. And oftentimes they're willing to make such representations in the contract. And so we would review this prior to contracting and then make sure that we have adequate representations within the contract dealing with their security posture. One very important note is that vendors often try to incorporate their security documentation by reference via a hyperlink in these agreements. And the problem with that is they always add a caveat, which is that they can update their documents at any point in time. And so we always recommend to clients, try to get those incorporated by reference hyperlinks added as an exhibit to the document, and make sure that you have a point in time reference of what you're agreeing to at the point of execution. So what does the white paper look like now? And then understand that you have an obligation to continuously review and enforce the security provisions if needed later on. All right, next slide.
So one final point in the pre-negotiation phase here is just a word about cybersecurity insurance. And I think folks over the last decade anyway have largely come around on this. Years ago, it was rarer to find vendors carrying cyber liability insurance. These days, it's more common. Clearly, in any relationship where a vendor is going to have access to sensitive data, that could result in the institution being held accountable to third parties, whether it's data subjects, government agencies, and so forth. You're going to want to take a close look at the vendor's insurance program to ensure that they're going to have the resources to make good on the protections we're going to require of them. And you'll see those are things like indemnity to protect us if we experience liability because they experience a data security breach, breach response, if we're going to compel them to fund responsive measures if a breach occurs. Again, you want to make sure that their program is going to respond. Don't rely on general liability insurance here. I think a lot of vendors, particularly those that don't operate in the technology sector, come at this and just say, okay, we've got GL, that's good enough. And when you drill down into those policies, you will invariably find that it's not good enough, either because you've got exclusions going to this kind of liability, or at a minimum, because they don't contain some of the response benefits that you're going to want to see in this space. So look specifically to their cyber policies. Speaking of the tech sector, other vendors, again, many have gotten to this space already just because the extent of this risk to themselves is widely enough known at this point. Some haven't. Most in the tech sector have. If by chance you encounter a vendor in the technology sector and they don't have cybersecurity insurance, that should be a significant red flag to you. In addition to just the fact that the protection of the insurance is not there for you in that relationship, honestly, it should also call into question how sophisticated they are in recognizing and analyzing these kinds of risks, and a lack of sophistication or capability on that front obviously has implications for you in terms of the risk they may bring to the table by being lax in their own security practices. Amber, anything else on insurance you want to offer?
The only thing I would say is we have been successful recently, especially in the tech vendor front, of adding in required insurance language right into the contract directly and naming clients, obtaining a waiver of subrogation and naming clients as additional insured with the sample language here. But once again, this is a question for the RFP process. So we want to know what the coverage is in the RFP process before we get to the contracting phase.
Okay, next slide, please. So now we're going to get into the contract terms themselves. We've previewed a little bit of that along the way, just in showing why we do the pre-contractual stuff that we do. But now we'll really get into just the nuts and bolts of this, negotiating the content of these agreements themselves. And the first thing to talk about is just establishing the vendor's general duty to safeguard our sensitive data. And the phrase you see at the top of the slide here, just a legal concept, the standard of care. What do we expect of them in terms of their diligence in protecting our information? And here, I mean, these considerations for us can arise from a variety of sources. One is just common sense. One is best practices, what is generally expected in the industry, both ours and theirs. And then obviously regulatory obligations. To the extent that we have regulatory obligations that obligate us to ensure that certain precautions are in place, there's a need to flow those down into these vendor agreements to ensure that they are giving us what we need to provide in order to be compliant from a regulatory standpoint. You've heard the adage before, less is more. In this space, less is most definitely not more. So you will get into a vendor contract and see a provision, for example, that says each party will use the same degree of care to protect confidential information of the other party as it uses to protect its own confidential information of like importance. Period, done, end of story. Basically, they're saying, we'll give your information the same protection we give our own information, which is wonderful if they are sophisticated and diligent in protecting their own information. But if they aren't, if they're not going to safeguard their own information, well, we darn well want them safeguarding our information. And so the sample you have on the slide here is illustrative of kind of the sorts of specific things we want to be talking about, right? And so we've got a general standard. We want you to take precautions, certainly anything that's required by law, but also we want you to act consistent with industry security standards in a way that protects all of this information, both from wrongful access, also wrongful disclosure, also wrongful use. And then we give some examples at the back end. And there are variants of this, right? There are some that go on. You see X and Y here. You see some that have 5 or 6 prongs to this. Here's just an example, right? We speak specifically to the concept of encryption. We speak specifically to the concept of having, intentionality, a written information security program. And again, that's another item of potential due diligence, kicking the tires on the front end, but this is where we bring it forward into the contract itself and make them promise contractually that they are going to take these kinds of specific precautions to protect information. Next slide, please.
Okay, so another area where we modify agreements in relation to data privacy and cybersecurity risk is the reps and warranties provision. So depending on the type of vendor you have, and especially if we're talking about a technology vendor, it's important to pull in considerations in relation to the product they're providing or the service they're offering, and that there are adequate representations and warranties in relation to that product. So oftentimes we'll see a representation that just says, vendor will comply with the law. And that's great. Of course, we want that. But we also want some specifics in relation to the services that they'll provide, so that they'll comply with applicable privacy laws, and that their software will function at a certain level of uptime, and that we'll have some specific promises from the vendor in relation to their product. And what I will say is oftentimes vendors do not have any reps and warranties in relation to the service. But when you push back on that and incorporate appropriate provisions, if they push back, the question is why, right? Stand by your product. Tell us that this will not cause any issues for us and will protect us from a privacy and security standpoint. So really important to do an adequate review of the reps and warranties in the agreement and make sure that we're covering that risk. The other area where we now have to modify vendor contracts is to make sure that we have appropriate data protection clauses. And this comes into play with the language that Phil was just talking about administrative, technical, physical safeguards, but that also if the contract is missing any language, we also need language around protecting personal information pursuant to whatever our regulatory obligations may be. So we may need FERPA language. We may need language relating to GDPR, which is the European Union Data Privacy Law. We generally may need language around student information or protecting the institution information in total. And so oftentimes vendor contracts are missing this provision, and there is no language surrounding protecting personal information. And so we want to make sure we've included that. Very important is to include appropriate data breach language. So what do we do if the vendor loses our information, if there's unauthorized access to or disclosure of the institution's information? We need to call out a specific reporting time frame from the vendor. What we don't want is for our vendor to sit and not tell us for 6 months that they had a data breach and potentially exposed all of our student information or our donors' information, right? We need them to tell us quickly. Sometimes that time frame is set from a regulatory perspective. So you may be bound by a law that requires you to report to a specific agency within a specific time frame. Market is 48 hours. So oftentimes we'll see responses within 24 hours to 72. And so the middle ground there is notice within 48 hours to the institution of a data breach. It's very important to note that you also want to make sure that the vendor is obligated to respond with appropriate remediation in relation to the data breach, right? So that the vendor is responsible for credit monitoring, for providing notice to affected individuals. There's a question of whether or not the institution wants to review that notice before providing it to the individuals. And so you want to ensure that you have some kind of data breach provision within these agreements. And I want to note that's even if the agreement does not focus on a service that necessarily narrows in on data, right? So of course, if you have a vendor that's an ERP system or some kind of software system that's collecting all of your data, you need to have this provision. But you may have a event ticketing service or some other kind of sales service on site where there is data at play, but it doesn't seem central to the agreement. You still want this language. You still want to ensure that the vendor has to notify you in the event of unauthorized access or disclosure of your information, because you may have obligations under the law. And what's really important to know is these are flow-through obligations, downstream obligations. So because it's the institution's data and you're providing it to a vendor, you may have obligations under the law and the vendor may have obligations under the law in relation to your data. And then finally, it's very important to determine what you want to happen with your information upon termination of the agreement. So if we're terminating the agreement, does the vendor need to provide you with your data back? Do they need to delete it? And how quickly do they need to do that? And are you going to mandate that they do that, right? So do you need a certification of deletion or a return within 30 days of termination? So very important considerations when we're talking about data security precautions. Phil, do you have anything to add there?
No, Amber, I think that's good.
Okay, great. Next slide, please. Okay, so now we get into really the meat and potatoes of every contract negotiation, where we hang our hats and we spend quite a bit of time, which is the limitation of liability and how vendors try to pass risk on to higher ed institutions or to disclaim any kind of risk. And so where we want to start here is with the indemnification. So this isn't specific to the limitation of liability provisions, but your vendor agreements often will include an indemnification provision, excuse me. And it's important to pull in data privacy and cybersecurity considerations into these indemnification provisions for a few reasons. One, under data privacy law, individuals often have a right to bring a claim, right? So they have rights in relation to their information, especially if we're talking about GDPR, that European data privacy law, and they have rights to file complaints with government agencies, but also rights to bring actions against institutions if they're not protecting their information. And so you want to make sure that you're giving fair consideration to expanding the indemnification provisions to include data security obligations, compliance with applicable law, compliance with the other provisions that we've talked about in the agreement, and to broaden the typical indemnification provision. Now, what I will say is most tech agreements, the indemnification provision is limited to intellectual property infringement. And so we often try to expand. This is a great place to review and try to mitigate risk by expanding that indemnification provision to include breach of the agreement and a data breach or compliance with applicable law as well. It's important to note that you can use this as a negotiating tactic when we're talking about the limitation of liability cap. So oftentimes we are successful removing the indemnification obligations from any type of limitation of liability cap. So if the vendor is setting the limitation of liability at 10 months fees paid, we can try to exclude their indemnification obligations from that limitation of liability cap to ensure that they're still responsible for any kind of data breach damages or any kind of third-party claims that may result from violation of the agreement, and that does not affect the limitation of liability cap. So it's another negotiating point or a negotiating tactic that you can try. Phil, anything to add there?
I don't think so. Maybe on that we can shift to talking about these wonderful liability caps.
Perfect. Next slide, please.
Okay, so you will, as Amber has already previewed, you will see vendors use a variety of provisions to limit their accountability for liability in this space, the data security space. You see these in several different forms. One is the first bullet you see on the slide here, just a disclaimer, right? So you will see vendors, again, this is more common in the tech space, that expressly disclaim any liability for loss or destruction of your data. The significance of that to you may vary. It may vary, among other things, by how frequently you have access to the data. Is there a backup system in place? Obviously, this can be significantly different for a cloud-based solution versus an on-premises type of solution as well. But the typical initial pushback from the institution is to request removal of that sort of that disclaimer, and barring that to negotiate off of it in different kinds of ways. More commonly and more prominently are liability caps. And again, Amber already previewed this a little bit, but the concept here is a vendor is saying, look, even if we do something wrong, the extent of recourse you have against us is going to be economically limited. These are wonderful, right? So a vendor does something wrong, causes you $2 million of exposure to a third party, and you go and everybody agrees it was the vendor's fault. You agree it was their fault. They agree it was their fault. And you go and look at your contract and, oh, shoot, you've got a provision that says, despite the fact that you've got to pay some data subject $2 million at this point, you can only go after the vendor to recoup $50,000 of that. So obviously a concern. These originated in the technology industry, and in particular in the software licensing industry. And the theory there, anyway, was it's not about fault. Much as we'd like to make it about fault, it's not about fault. Their claim would always be, no, this is about economic balancing. So I'd have this exact conversation with them, right? You'd say, okay, let me get this straight. We all agree it's your fault. You agree it's your fault. I suffer $2 million in damages. You only have to fund $50,000 of that. How is that fair? And the software vendor would say, well, Phil, it's not about fairness. It's not about fault. It's not about right and wrong. It's about the cost of our product. And we are releasing our software solution into the marketplace to be used on systems whose capabilities we are not familiar with fully, to be used by people whose competencies we are not fully familiar with. If we had to accept unlimited liability, if anything ever went wrong with our solution, you could still have the product, but instead of costing you $50,000 a year, it would cost you $500,000 a year. We need this as a matter of economic balancing. Whether you agree with that proposition or not, these caps, in that particular industry segment have become fairly standard. And we're going to talk about how you negotiate to mitigate the impact of those caps on you as an institution. But the other thing you'll find is that every vendor under the sun woke up at one point and said, hey, this is really neat. We can limit our exposure in our contracts with our customers. And whereas with a software vendor or another technology vendor, you could understand just because of the unpredictability of those services and the environment in which they operate, you have vendors who are physically present on your campus, coming and having complete control over what they're doing at any moment in time, still purporting to say, hey, you know what, if we come on campus and somebody gets injured, just garden variety personal injury case, even if we were at fault, even if nobody from the institution was within 100 yards of what happened, you can only come after us for a limited amount. And, those provisions in those contracts, they don't have the same kind of logical basis as they do in a tech contract. And frankly, whereas within a tech contract, you may take an initial run at getting rid of the liability cap and you will be universally rebuffed and then have to negotiate off of that. With some of these other kinds of vendor contracts, I would encourage you to push particularly hard on the front end on the idea that those liability caps are just inappropriate in these other non-techie kind of contexts. So that's kind of the background. Now, okay, we see one of these. What do they look like, and what's our response? You see them in several different versions. By far the most common, at least in terms of the first proposal by a vendor, is going to be what's known as a fee-based cap. And there the idea is they're willing to, at maximum, give back in the form of liability protection to the institution part of what they're earning under this relationship. Not more than, not all of it, and certainly not more than that. And so you will often see these expressed as a limitation. No matter what happens, under no circumstances, the vendor liable to the institution for more than, for example, the fees paid in the 12 months preceding the incident that gave rise to the liability. Interesting from an economic standpoint, also interesting from a timing standpoint. How you react to this is going to be in part based on what do you see as the magnitude of the potential risk compared to how many fees, what's the volume of fees that you're paying. If this is a $2 million a year contract, maybe you don't feel so bad about this. If it's a $10,000 a year contract, you're going to have some problems with this. The other is timing, though. I mean, if you look at a cap talking about the preceding 12 months worth of fee payments, what happens if the incident giving rise to liability occurs 2 days after the effective date of the relationship? This cap doesn't do you any favors there. So you want to be thinking about that in terms of how you negotiate off of that. There are other varieties of fee caps, and sometimes you see them in the contract right from the vendor. Oftentimes these are the kind of things we negotiate to after getting a vendor to agree to depart from a fee-based cap. For example, a fixed amount, right? So you say, okay, we're not going to argue over whether it's 12 months worth of fees or 36 months worth of fees or 24 months worth of fees. Here's what we're concerned about. We think you should be liable for up to $500,000. So we'll fix the liability cap at $500,000. One of the benefits of that is it avoids the conundrum of what happens when the incident happens 2 days into the relationship. You've got that $500,000 in protection available. Another solution sometimes is to tie the cap to the insurance that the vendor maintains. So we talked earlier about the importance in a due diligence kind of a way of familiarizing yourself with what kind of insurance and what types and having what limits a vendor carries. You can have a conversation with the vendor if you're comfortable with their insurance program, saying, hey, look, this is not coming out of your own pocket. You maintain this insurance for a reason, to protect against this very scenario. If something goes wrong, we want you to agree that your liability will be coextensive with how much insurance you have available for the claim. But we're saying we're not going to require you to dig into your own pocket past that, other than, and this is important to note when you negotiate these provisions, if the vendor has some kind of gargantuan deductible or self-insured retention, you need to specify that they're responsible for paying that, not you. But you can set the cap at the upper limits of the insurance. And then last but not least, one of the things you'll see is what's known as a super cap, where we basically say, okay, for general types of liability, we're willing to accept a cap of a certain amount, but for other types of liability, and in particular liability arising out of data security problems, the cap is different. It's higher, hence the name super cap. These are all things you can negotiate to when you're confronted with something in a vendor's contract that you don't like on the front end. So we're going to spend a couple minutes just looking at some examples of this. Before we do that, Amber, anything else from a conceptual standpoint?
Yeah, so the one thing I would add here is it's really important to do a risk assessment and a full risk assessment of the length of the contract and the data at play. So we go right back to that original question. If the vendor is going to have all of your data, then we may, and the fees paid may be $50,000 a year. We'll use Phil's example. The risk profile on that is much more significant than $50,000 a year. And so when you're trying to determine what type of negotiating, what type of liability cap you want to negotiate, you want to take those into consideration, right? If the fees are going to increase substantially over the course of a 10-year term, you may want to do a fees paid amount because you'll have an increase in the liability cap as you continue on. If the risk profile is so substantial that the vendor may be accessing all of your data, it may make sense to use a super cap approach in that that you have this massive outstanding risk and you want to ensure that there are 2 tiers of liability so that we're mitigating that risk in that second tier. So other than that, I think we're good to move on.
Okay, next slide, please. All right, so here are just an example. I'm cognizant of our time limitation here, so I'm not going to spend a lot of time on this, but just real quickly. So upper left, you have a flat fee approach there. The negotiated amount is $100,000. The other thing to note here is the front end of that provision. As we mentioned before, as Amber had mentioned, the institution here has carved out of the liability cap data breach or breach of confidentiality or indemnity obligations of the vendor. So those just don't get capped at all. Everything else is capped at $100,000. The lower left is your fee, your typical fee-based cap, right? 3 times the fees paid during the 12 months preceding the event giving rise to the claim. And then on the right-hand side, you have an insurance-based provision Again, at the front end of that, there are some carve-outs as to particular type of liability. So the institution did a good job there, excluding those from the cap. And then down at the bottom, you see the insurance-based cap language. Next slide, please. Here are your super cap approaches, right? Left-hand column, general cap of 2 times fees paid, but then a higher cap, 3 times fees paid for liability arising out of confidentiality breaches and data security and privacy breaches. Similarly, on the right-hand side, there you see a fee-based cap where you've got a 12-month general cap, but then a 24-month cap for breach of confidentiality, security, or privacy obligations. The other thing to note here, what's good for the goose is good for the gander, right? These, when you get them from the vendor, will oftentimes limit only their liability, but not yours. One of the other pushbacks here, both because it gives you the obvious benefit, but also because it can incentivize them to bump up the amount of the cap, is to say, okay, if we're capping our own liability, if you're capping your liability, what's good for the goose is good for the gander. You cap our liability as well. Next slide.
Okay, so we had mentioned this earlier, but we wanted to circle back to it, which is that oftentimes when reviewing these agreements, you may have regulatory compliance obligations that need to be built into the agreements from a privacy or data security standpoint. And so it's very important to take those considerations and pull them into the agreement as necessary. And so a few examples of that, if we're talking about student data and we need relevant FERPA language to designate the vendor as a school official, you want to make sure you pull that into your data protection clauses that we talked about earlier. If we're in the EU GDPR space or China's PIPL, which is China's version of GDPR, you may need a data protection addendum or required contractual provisions under that specific privacy law. That's true for many international privacy laws. So if we're talking about a student exchange agreement or any kind of study abroad agreement, or any agreement where we may have international student data, if it's admissions and we're talking about a software that processes prospective student information, you may need to include those provisions. It is important to note that you want to designate where data is stored, and you want to vet the vendor to ensure that they're storing your information in the United States. Any kind of international storage may pull in foreign data privacy law. So it's an important consideration when you're reviewing the agreements. And then finally, it's important to note that if your agreement it deals with any kind of foreign transaction or individuals located in foreign countries, you may need to include a data transfer agreement as well to allow for international transfer of information. And that's true if the local country has a privacy law. So an important consideration there. Okay, next slide, please. And I understand we're running out of time, so I'll just go over this quickly. One thing we haven't talked about in detail is functionality and cybersecurity risk. And so it's really important, if we're talking about a technology vendor, that the software they're providing or the service they're providing meets the appropriate uptime and functions, because another area of risk for institutions is that the agreement that you're entering into, the service you're asking the vendor to provide, doesn't function properly. And that could be extremely detrimental to institutions. So you want to ask the vendor if they have a service level agreement, and you want to review those at the same time, contemporaneously as the underlying document, because there may be room to move in relation to the credits they have to provide or the promised uptime that they will provide. And then finally, it's really important to make sure you're doing a periodic review of your vendor agreements. And upon renewal, it's a great time to renegotiate old or stale agreements to make sure you're now incorporating some of these privacy and cybersecurity risks and trying to mitigate them through the provisions we've talked about today. Bill, anything else to add there?
I would just say, that's good for the obvious reason, right? To improve the protections that you have The other thing that we've seen is that the laws in this space change monthly, right? It seems constantly we have another jurisdiction adopting a data security law or updating what they've got on the books. And so, continual attention to this is warranted. But certainly when you have relationships that are up for renewal, again, if you've got to update the health of the language in there because your own compliance obligations have changed, there's an obvious reason to reopen it there as well. The other thing I would mention, just on with respect to the previous slide, Amber had mentioned the importance of figuring out and addressing in the contract the location of data storage, because that may unwittingly implicate some particular jurisdictions' data privacy laws. There's another due diligence item for you. Even before you get into the relationship, having a conversation with prospective vendors about where they store data, so that you know whether you're going to run into that or not. And if you are, at a minimum, being able to preload with them the idea that they're going to have to agree to particular regulatory-based compliance obligations if they insist on storing data in a different location.
Exactly. Okay, next slide.
So that is pretty much what we have for you today. Hope it's been informative. Again, we've done our best to answer questions that have popped into the Q&A thus far. If folks have follow-up questions on this, Amber and I are always happy to speak with you, as are other members of our higher education and data privacy practice groups. Feel free to reach out at any time. The slide that you have in front of you right now are the remaining installments of this series. Again, each of them featuring the intersection of data privacy and cybersecurity in the higher education space. And we'd invite you to join us for all of those if your time permits. So thank you again, everybody, for your time. And we look forward to speaking with you soon.